has been made to provide procedural guidance to lodging parties regarding the lodgement process for a grant application with the South Australian Probate Registry. This video is general in nature and does not provide specific guidance with respect to all types of applications. Court staff cannot provide legal advice. If you require legal advice concerning your application, you should speak to a lawyer who specialises in the area of wills and estates. This video is about what you need to do once you have lodged your grant application via Court SA. For applications for probate, les administration with the will annexed, or registration or a reseal of a grant, you must lodge the original document, i.e. the original will and codicil, if applicable, or the original court authenticated grant. After lodging your grant application via Court SA will automatically create several documents for you that will appear in your case under the Documents tab. They are the original will or grant cover sheet, the grant application, and the Statement of Assets and Liabilities. Please download and print the original will or grant cover sheet. Stick the cover sheet to an envelope, by preference an A4 envelope, and in the space provided on the cover sheet, provide details of what will be enclosed in the said envelope. Place the original will and codicil, if applicable, marked in accordance with Rule 356.5 of Chapter 25 of the Uniform Civil Rules 2020, or the original court authenticated grant in the envelope. If you are a personal applicant, your certificate of identity, any oaths or affidavits or other supporting documentation must be enclosed in the envelope too. The envelope should then either be dropped off in person at the Sir Samuel Way building at 241 to 259 Victoria Square, Adelaide 5000, or sent by registered post to the Probate Registry at Sir Samuel Way building 241 to 259 Victoria Square, Adelaide 5000. Your application will not be considered until the original will and codicil, if applicable, or the original court authenticated grant has been lodged. Regarding applications for les administration, once the application is lodged, it will be placed in the queue for examination in the Probate Registry. Personal applicants, however, must lodge their original hard copy oath of administrator and their certificate of identity before a grant can issue. Please note that the oath and the certificate of identity must be completed on the same day and in the presence of the same authorised person. As mentioned above, if you're lodging a grant of probate or a grant of les administration with the will annexed, and if there are any codicils, you will need to mark the original document. This is to be completed before you lodge the original will and codicil, if there are any, with the court. This is under Rule 356.5 of Chapter 25 of the Uniform Civil Rules 2020. And it provides that the original will and any codicils must be marked by the applicants. The following marking, where my pointer is circling, must appear on the reverse side of the last page of the will, if the pages of the wills are attached, or if the pages of the will are separate, unattached pages, then the marking must appear on the reverse side of each page of the will. Or if you have a document that is double-sided, such as a will kit, then the marking should appear along the margins, or wherever there is space. The same applies to any codicils. The marking is to contain 1. The signature of the applicant, and 2. The signature of a commissioner for taking affidavits, justice of the peace, or any other person duly authorised to take an oath, and 3. The authority of the person authorised to administer oaths, either stamped or written, and 4. The date signed, and 5. The suburb and postcode where the marking occurred. Please ensure the marking does not cover any content of the will and or codicil, if there are any. If there is testamentary writing on the back of the only page or last page, carefully mark that page so as not to obscure any testamentary writing. Please take care in marking. If any ink from pen or stamp leaches through to make any of the will difficult to read, you may be required to provide an engrossment. Refer to Rule 356.13 of Chapter 25 of the Uniform Civil Rules 2020. When the will is contained in a will kit booklet, the mark should be on the will itself, not on some part of the booklet. Please do not scan the back page unless it contains part of the will or codicil, if there are any codicils. And you may wish to make a clean and publishable copy of the will and, if there are any codicils, before you mark them. Now, certificate of identity. For personal applicants, you have the additional requirement of lodging a certificate of identity, no matter the type of grant application you are lodging. Please refer to Rule 351.8 of Chapter 25 of the Uniform Civil Rules 2020 and Practice Note 4 of 2024 regarding personal applicants for more details. The certificate of identity, including the certification of your identity documents, must be completed by an authorised person, i.e. a person authorised to administer oaths. The same authorised person must also witness you marking the back of the original will and any codicils, if applicable, and complete the Rule 356.5 marking themselves. This all must be done at the same time. If you have an oath of administrator, such as a grant of les administration or a grant of les administration with the will annexed, again, the same authorised person must witness your oath and complete your certificate of identity. Once your application has been lodged online and any original documents have been received by the registry, your application will be placed in the queue for examination. The application will then be examined to make sure it complies with the relevant rules and legislation. Receiving a grant is not an automatic process. If there are any questions with respect to your application or if further information is required, you will be sent an email. If you require assistance with what is being asked of you, you should speak to a lawyer who specialises in the area of wills and estates. Court staff are unable to provide legal advice. Once any queries are answered and the application complies with all the requirements, the grant will be issued. After the grant has been issued, you will receive email notification. Log back into Court SA, go to your case and the Documents tab. The grant and any registrar certificates will be sitting under the Documents tab. Please note the Court does not seal and produce paper grants nor paper registrar certificates. The Court only seals an electronic grant and electronic registrar certificates. They are the originals. Please also note that the probate registry is not involved in the administration of the estate nor any litigation. If you find an additional asset or realise that an asset has been inaccurately described, please refer to the probate page on the Court Administration Authority website as to what you will need to do. You can find it under Frequently Asked Questions and it is set out in detail the process.